Good morning, everyone. Paige and I would like to welcome you and thank you for joining us this morning on this webinar on data and employees, the law after Morrison's Supermarkets. Just by way of a few preliminaries, we're going to cover quite a lot of ground in 30 minutes. So if you've got any questions, please either use the chat function or send us an email, or send an email to Paul Cray, whose details were provided with the joining instructions. Can I ask you to also just to remember to ensure that you're muted, as we are all on Zoom, and background noise can sometimes interfere. Judging by the numbers of people who have joined us this morning, this is obviously a topic, an issue of very topical interest. What I'd like to do is start with a rather topical story, which you may all have seen in the news last week. It was the hack of Twitter. We had a number of high-profile accounts which were hacked, the Twitter accounts of entities such as Apple, Uber, Tesla, Elon Musk, the US presidential candidate Joe Biden, these accounts were taken over by hackers for as part of a Bitcoin scam, and various posts were sent out. And this is the post which was sent out from the Uber account, which invited you to send Bitcoin to a particular address. There are 3 addresses, and if you sent some Bitcoin to those addresses, apparently you were going to get some more Bitcoin back. Quite a few people actually responded to this invitation. The only problem was the hackers also hacked the accounts of various cryptocurrency exchanges, and they got wind of this and blocked these addresses. So in fact, actually, the hackers didn't make away with an awful lot of Bitcoin. But what was interesting about this was not your usual computer hack involving hackers taking control of computer systems remotely. This was done by taking control of certain Twitter employees. They were targeted through what was described as a social engineering scheme, which Twitter described as the intentional manipulation of people into performing certain acts and divulging certain information. So here you have hackers who had identified the real weakness in the Twitter systems, not in the systems themselves, but in the individuals, those trusted employees who were responsible for looking after the system. Now that's something which lawyers in this area, and I'm no exception, will have had plenty of experience. I can't think of the number of times that I have gone off to court to get search orders and injunctions to stop the misuse of confidential information, customer databases, customer lists, and all that sort of thing. And often the culprit is a senior IT employee. And what I'm going to do is just start by looking at a case I did quite a few years ago now, called Flowgas and Calagas, which was a sort of typical type of scenario involving employees misusing customer lists. Here you had a employee, X we'll call him, who took a copy of Flowgas's bulk customer data. He was a senior trusted employee of Flowgas who worked in the IT section. He then passed a copy of the database on to Y, who was a former senior employee of Flowgas, who became an employee of Calagas. He then passed it on to another individual, Z, who was the senior marketing executive of Cala. Well, what happened then was that Z arranged a partial mail shot using the database by Cala to a large number of Flowgas's bulk customers, that's bulk LPG customers. Well, what happened is Flowgas found out about this, and we went and got the usual sort of search orders and orders for interim injunctive relief, but the matter ultimately made it to trial. And at trial, there were a number of quite interesting issues. The claim was essentially one which was for the quantification of losses, because a breach of confidence had been admitted. But what was in dispute was whether or not Flowgas was also entitled to damages for infringement of its database rights, under Regulation 13 of the Copyright and Rights in Databases Regulations 1997. And that depended in part upon whether or not CALA was vicariously liable for the actions of Z being senior marketing executive. The senior management team of CALA didn't know anything about the misuse of the database. And so they were saying, well, this was a frolic of Z's own, and therefore they weren't liable. Well, the judge wasn't having any of that and found for Flowgas on the issue of vicarious liability. Z was carrying out her duties for CALA Gas when arranging the mail shop, and was doing it to benefit CALA Gas. And that's perhaps an important contrast which one can draw with the Morrison's case, which Paige will talk about in a little bit more detail shortly. Now, the sort of risks which employers face from the actions of its employees can be quite considerable. I mean, there's obviously the prospect of enforcement action by the ICO. And an example is the British Airways fine of £184 million, and that's currently under consideration. And then there can be reputational damage. You may remember the hack of TalkTalk, and as a result of that, it lost something like, I think, 250,000 of its customers. And Yahoo suffered rather badly when I think 1 billion of its user accounts were hacked some years ago. And so you can have damage to reputation, which can be quite significant. You can have commercial claims which arise, as in the Flowgas and CALA Gas type of claim. You can also have shareholder claims. This is one which people don't often think about, but you see it in the United States. You have derivative claims brought by shareholders. In Home Depot, shareholder derivative litigation is an example of that. They haven't tended to be rather successful. But by way of contrast, in connection with Yahoo, claims were brought for infringement of various disclosure obligations under the securities regulations in the United States, in connection with comments and statements made in connection with the Yahoo systems, and which proved to be untrue as a result of the hack. And that was settled in 2018 for a significant sum of money. But the really interesting development in this area is the increase in data subject actions. And I'm going to focus in on that now. Traditionally, there are 3 causes of action which are invoked for these types of claim. The first, misuse of private information, and that's a tort which is designed to protect private information, real sort of private information about people's personal lives, the sort of thing which you read about in terms of celebrities in newspapers. And of course, a lot of the litigation arose out of the phone hacking scandal. So misuse of private information is one type of cause of action, not likely to arise in your standard hack or data misuse, because a lot of time the data which is taken or divulged is of itself not particularly salacious or interesting, but still it may cause a lot of distress. Breach of confidence is another cause of action which is used, which relies upon equitable principles, and that gives rise to quite interesting issues as to the extent to which issues of vicarious liability even apply in that area. And then, of course, you've got breach of statutory duty, and you've got in that respect, you've got the various statutory provisions which can give rise to various claims for compensation. And compensation is really the key to this. There have been a number of things which have been driving forward the concept of data subject actions. Firstly, there are social issues. We are now very much more aware after GDPR that we have data protection rights. The rather large administrative fines which can be levied perhaps have given some credence to the idea that actually there's large amounts of cash which may be available if one brings a claim, and the compensation could be at a rather high level. And the reality is, until fairly recently, there's been a number of legal impediments to the claiming of compensation. And the starting point was initially in connection with the Data Protection Act 1998, Section 13(2), which required you to establish that you suffered a pecuniary loss before you could recover damages for distress. That was got around quite handily by the courts by, for example, awarding nominal damages and regarding that as a pecuniary loss. And an example of that is Halliday and Creation Consumer Finance. But in 2015, the Court of Appeal cut through all of that and actually struck down Section 13, subsection 2 of the Data Protection Act, disapplied it on the basis that it conflicted with Articles 7 and 8 of the EU Charter of Fundamental Rights. And that opened the way up for claims for distress to be made for distress alone. You then had Gulati and MGM, another important case from 2015, which established that you could be awarded compensation simply for the loss of control of the information, and that distress was not an essential component of the tort. So if you have that, it's the idea that if you had valuable personal information and you lost control of it because of a hack, and it made its way into the newspapers, substantial compensation could be awarded for that, and the figures were in the sort of region of maybe 10, 20,000 pounds, that sort of thing. But again, these were quite serious matters, quite serious breaches of quite private information, which made it into the newspapers. You also have quite serious cases where data can have, the data breach can have quite significant impact upon people's mental states. And an example of that is TLT and Secretary of State for the Home Department, where the Home Department inadvertently published a spreadsheet which provided details of various families who were, some of whom were asylum seekers. And TLT and his wife TLU, for example, were seeking asylum from Iran. They were Iranian citizens, and word got back to them that following the breach and the divulging of the publication of the information, various people had visited relatives back in Iran, and they were so concerned that they actually moved house, took their children out of school, and moved away from the area, and essentially went into hiding. They were very, very concerned, and exceptional cases can give rise to awards of compensation, which are akin to awards of psychiatric and psychological damage. And you had a TLT and his wife TLU got £12,500 in that case. But what about the more humdrum breach, the sort of breach which, whilst one can't condone it, doesn't really give rise to any real distress? Well, that's now the subject of consideration by the court in Lloyd and Google. And this has been a fascinating case, which is going through the courts at the moment. It's a class action for about 4 million iPhone users arising from the use in 2011 and 2012 by Google of what was called the Safari workaround, which enabled Google to track the browser activity of users of iPhones. And that information was then sold on for commercial gain. Proceedings were brought, no distress was alleged, and compensation for use of the data without consent was the only loss which was alleged. And in terms of a value of the claim, the only indication which we've got so far is that the figure of £750 was suggested in the letter of claim, which equates to a total value of the claim of about £3 billion then. So it started off before Mr. Justice Warby on an application to set aside service of the proceedings. And one of the issues which arose there was whether or not the proceedings disclosed a viable claim for compensation. And the fact that the only thing which was being claimed was compensation for use of the data without consent gave rise to the issue as to whether or not that of itself could be regarded as a compensatable loss. Warby, Mr. Justice Warby said, no, that's not on the existing state of authorities. It got to the Court of Appeal, and the Court of Appeal allowed the proceedings to continue and said that, and I'll come on to the detail of this in a minute, said that actually this could be a compensatable head of loss. The Supreme Court has granted permission to appeal. It granted permission on the 11th of March of this year, and so sometime later this year, or more likely early next year, we'll hear what the Supreme Court has to say about it. But what did the Court of Appeal say? Well, four things. Firstly, this is a matter of EU law, and I should say that it really doesn't make any difference that Brexit is happening, that we're maybe leaving the EU at the end of the year. The principles are still going to, same principles are still going to apply going forward. But what was interesting was the Court of Appeal bought into the idea that control over data is an asset which has value, and I think one could see that. They gave an example of free Wi-Fi at an airport. You can obtain free Wi-Fi at an airport if you share personal data. You agree to share personal data, and that can then be used by advertisers. If you don't want to do that, then you can pay for it, and you can pay for your Wi-Fi. And they gave that as an example, and I think that it must be right. As society, we do now regard our personal data as an asset which has value, and indeed commercial organizations regard it as an asset which has value. One can find support for it too in GDPR recital 85, which is dealing with notification of breaches, but the point was there anyway, and the Court of Appeal alluded to it. A personal data breach may, if not addressed in an appropriate and timely manner, result in physical, material or non-material damage to natural persons over their personal data. The concept really is not one which is foreign to English law either, and one can see that in the idea of what are called user negotiating damages, which are recently considered by the Supreme Court in Morris Garnier and One Step. Some people refer to these as Rothman Park damages in the property law context, and it's been used in a number of different contexts where there's been no actual damage, but it's only right that somebody pays for the use which they've had of something which somebody else would otherwise have been able to control. So again, I don't see it as particularly groundbreaking, but it's important in the sense that it gets the data claim in Lloyd and Google off the ground. Now, going forward, I think the important thing to remember, though, is that when one is dealing with data protection issues, generally speaking, one is looking at the relevant regulations and considering first the primary liability of employers. And the starting point would be GDPR Article 82. Any person who has suffered material, non-material damage, etc., shall have the right to compensation from the controller or processor. That's Article 82.1. It's mandatory, and it is as the result of a result of an infringement. So there are issues about potentially whether or not that broadens out the issues of causation. And there's a demarcation between controllers and processors as to how they can be liable. But importantly, at 3, a controller or processor shall be exempt from liability under paragraph 2 if it proves that it is not in any way responsible for giving rise to the damage. So it really shifts the onus onto the controller or processor, and not in any way responsible, I would suggest, is quite a high hurdle. And if one looks at the underlying obligations, which on processors and controllers, you can see that this is just ripe for potential litigation. I look at Article 32, which sort of sets out the standard which one would apply in considering actions of a controller and processor. And you see it's couched in language which talks about the level of risks, using appropriate technology and organizational measures, etc., appropriate to the risk. And one can see that that's just the sort of thing which experts can readily disagree on in connection with the processing of data in an area where, of course, technology is moving on quite rapidly. And GDPR also recognizes that one has to take risks to deal with employees. And if one looks at Article 32.2 and Article 32.4, you can see that although not specifically mentioned in certainly Article 32.2, where it speaks of taking steps to ensure that there is no unauthorized disclosure of personal data, for example. And then Article 32.4, the controller and processor shall take steps to ensure that a natural person acting under the authority of the controller or the processor who has access to personal data does not process the data on instruction other than on the instructions from the controller, unless he is or she is required by union or member state law. With that, I'm now going to pass over to Paige, who will now take you through the Morrison's case in a bit more detail.
Thank you, Chris. As many of you will have spotted, in April this year, the Supreme Court handed down their decision in Morrison Supermarkets and Various Claimants. This decision is especially important for employers because in it the court clarified and arguably corrected the law on vicarious liability. And in doing so, they pulled back from the very expansive interpretation that had been gaining ground ever since their earlier decision in Mohammed. Before we turn to the meat of the decision, let us briefly recap the facts of the Morrison case. Mr. Skelton was a senior IT internal auditor and he was employed by Morrison's. As part of his job, he was asked to collate all of the data that was required for an external audit of Morrison's financial accounts. KPMG, who were acting as the external auditors, required extensive amounts of data in order to carry out the audit, including the payroll information for all of Morrison's 120,000 employees. It goes without saying that the payroll data was highly sensitive, containing not only the employees' names and dates of birth, but also their home addresses and their bank details. The full payroll data, including all of these sensitive elements, was made available to Mr. Skelton so that he could carry out the task that he'd been asked to do. And in November 2013, he duly transmitted this data to KPMG as he'd been asked. However, entirely unbeknownst to his employer, Mr. Skelton surreptitiously downloaded a copy of this information onto a personal USB stick before he deleted it from his work laptop. From this personal copy, Mr. Skelton made two sets of unauthorized disclosures. Firstly, he uploaded the payroll data to a file sharing site on the internet, and then sometime later, on the day that Morrison's financial accounts were to be publicly announced, he sent discs containing the data to 3 newspapers. Now, while Mr. Skelton never confirmed exactly why he did this, the judge in his criminal trial found that he was motivated by an irrational desire for vengeance against his employer. This seemed to stem from some really quite minor disciplinary action that he had faced a short while before, after he was discovered sending packages of a suspicious but ultimately legal white powder through the Morrison's post room, causing widespread panic. The judge found that as a result of this disciplinary action, which only consisted of a verbal warning, Mr. Skelton harboured a grudge against Morrison's. And really, from this point onwards, he concocted a plan to cause maximum harm to his employer in retaliation for the way he felt he'd been poorly treated. By the time this case reached the Supreme Court, primary liability was no longer an issue, and the only questions for the court to decide were related to secondary liability. In addition to having to clarify the limits and the scope of vicarious liability as a general principle, the court was also asked to decide some very specific points on the interaction between vicarious liability and data protection. In particular, on whether the Data Protection Act 1998 was such that it excluded even the possibility of vicarious liability for torts of information. Now, as I've said, primary liability was not an issue before the Supreme Court, but it's nevertheless worth a quick detour to consider why it was the judge in the first instance concluded that Morrisons were not themselves primarily liable in relation to the disclosures. As Chris has said, ordinarily, primary liability will be the way to go for a claimant. So in many ways, Morrisons is instructive as the example that proves the rule. The claimants sought to advance their direct claim against Morrisons by reference to the three classic causes of action we've already heard about. They sought to establish, first, a breach of statutory duties in the DPA, second, the common law tort of misuse of private information, and third, the equitable tort of breach of confidence. All three direct claims, direct causes of action failed, and this aspect of the decision wasn't appealed up. In short, the second and the third direct claims failed on a very simple point, in that Morrison themselves had not actually committed the relevant action the tort focuses on. They hadn't misused private information, nor had they breached any confidences themselves. However, the claimant's claim for breach of statutory duty under the DPA detained the court for rather longer. In essence, the claimant's argument was that at all material times, Morrison was the data controller in respect of the payroll data, and therefore that by allowing Mr. Skelton to disclose this information, they had breached their own data protection obligations. These arguments unfortunately failed to find favour with the court. Mr. Justice Langstaff found that while Morrison's was the data controller of the original data set, he was not the data controller, Morrison's was not the data controller of the information that was actually disclosed. Instead, the court accepted that at the point that Mr. Skelton started making his own decisions about the purpose for which and the manner in which this data was to be used, in effect, when he took his own copy, he became a data controller of that copy information in his own right, and it was that copy that was disclosed. The fact that Morrison's remained as data controller for the original data set was, in the view of the first instance court, irrelevant, as that original data was not the subject of the breach. Mr. Justice Langstaff also considered whether Morrison could be said to have breached their obligations in relation to the original data set, in particular to provide appropriate technological or organisational measures to prevent unauthorised disclosures, the wording of Data Protection Principle 7. When considering this point, Mr. Justice Langstaff took a very pragmatic approach and was willing to accept that regardless of the systems that employers might put in place, the risk of a data breach from an employee cannot be mitigated entirely. So following that, in the main, he rejected the claimant's suggestions about what further actions Morrison should have taken. But the court did find that Morrison had breached their obligations in relation to the original data set in one crucial respect. And that was that they had failed to put in place an organised system for the deletion of data from employees' computers. In the opinion of the court, allowing sensitive data to just sit on employees' machines gave rise to an unacceptable risk of inadvertent or in this case, deliberate disclosures. And this could easily have been avoided with some appropriate measures taken at the organisational level. For this reason, Mr. Justice Langstaff did find a breach, but primary liability wasn't established because of causation. On the facts, the court found that by the time that any schedule for deletion would have kicked in, Mr. Skelton would already have copied the data onto his own USB stick, and therefore Morrison's failure couldn't have had any causative effect on what came later. Before moving on, it's worth noting that had the claim been brought under the GDPR, the result may have been different. Now, as we've already heard from Chris, Article 82 of the GDPR gives a right to compensation where a person suffers damage as a result of an infringement. Now, this appears to be wider in scope than pure direct causation or but-for causation, meaning that it's at least arguable that a traditional causation defence of the type that we're all familiar with would struggle to succeed. However, the jury is still out on this, and it's very much a debate for another time, but worth keeping in mind should these issues arise. Turning then to the issues that were argued before the Supreme Court, and the question of whether vicarious liability is an available cause of action for torts of information. Morrison sought to argue that under the terms of the Data Protection Act 1998, specifically Section 13, which is on the slide, it was not possible to hold an employer vicariously liable for an employee's data-based tort, whether that's a breach of the DPA, misuse of private information, or breach of confidence. This argument had already failed twice, but it was run again before the Supreme Court. In essence, Morrison relied on the fact that a statute can, expressly or by implication, exclude vicarious liability for breaches of itself. Morrison argued that on a proper interpretation of Section 30, that liability for data breaches can be imposed only on the data controller and only where that data controller has failed to act with reasonable care. On this argument, then, Morrison said the statutory scheme is entirely inconsistent with the imposition of vicarious liability. Vicarious liability, by definition, is strict liability on an employer, whereas the statute envisages fault-based liability only on the employee themselves. So the argument went, as the statutory and common law schemes are inconsistent, the former has to be taken to exclude the latter. Now, it may not be entirely surprising that this argument failed. And indeed, the Supreme Court had very little hesitation in rejecting Morrison's position, with just two brief reasons. Although these comments are strictly obiter, in reality, they have largely shut this avenue down for employers. It was quite clear what the Supreme Court meant. Now, the first reason the Supreme Court gave for rejecting Morrison's argument is that the actual wording of Section 13 is silent on the position of the data processors or data controller's employer. Morrison may have argued that it envisaged liability only on a controller, but that word doesn't feature in the text. It was read in by Morrison's. Therefore, just getting out the starting blocks, it's quite difficult to see how there could be this inconsistency between the DPA and vicarious liability. The second reason the Supreme Court gave for rejecting Morrison's argument is even more fundamental, and it is quite basic, but is worth going over again. The court found that as a matter of principle, there is nothing inconsistent between primary liability being fault-based and secondary liability being strict. Indeed, as the court itself pointed out, this is the case in many of the paradigm instances of vicarious liability. For example, any case where an employee negligently injures a third party when they're carrying out their duties, no one would say that vicarious liability isn't possible there. For these two reasons, then, the Supreme Court found that the DPA doesn't exclude, impliedly or otherwise, a claimant from trying to rely on vicarious liability. Although it wasn't considered in Morrison's, it is worth noting it's very likely, given the Supreme Court's reasoning, that the same result would be arrived at under the DPA 2018 should the matter arise again. But the sum total of this part of the court's decision is that despite Morrison's valiant efforts, it remains possible for a claimant to bring proceedings against an employer on the basis of vicarious liability for their employees' information taught. But of course, the fact that vicarious liability is available as a cause of action certainly doesn't mean that the claimant will be successful in establishing it. In Morrison itself, for example, the Supreme Court, as we've seen, were very happy for the claimants to pursue vicarious liability, but on the facts, they found that it wasn't laid out. Now, a lot of ink has been spilt and a lot of words have been said on the approach of the Supreme Court to vicarious liability in this case. So I won't go through it with a fine-tooth comb, but suffice to say that the Supreme Court made a number of observations which put the brakes on and I think really can be seen to reverse the expansion of vicarious liability that was starting to occur after their decision in Mohammed. In Morrison's, the Supreme Court reiterated that it is not sufficient for a claimant just to show a causal or a temporal connection between the tortious actions and the primary tortfeasor's employment. A central consideration for the court, and indeed perhaps the central consideration, is the capacity in which the employee was acting when they committed the tort. Where the employee was acting, however bizarrely, however wrongly, on the employer's business, it is likely that vicarious liability will be established. For example, in Flowgas, the case that we heard about earlier, the employee illegitimately used the customer database of a competitor, but he did so in an attempt to further his own employer's business, and therefore it was ripe for vicarious liability. In contrast, where the employee is acting for their own personal reasons, vicarious liability is much less likely to be established. In this sense, whatever Lord Toulson may have said in Mohammed, the motive behind the employee's actions, the goal that they have in mind when they act, is crucial. Given this view of the law, it was very easy for the Supreme Court to find that in deliberately setting out to damage Morrison's and to get revenge on them, Mr. Skelton was not acting in the course of his employment when he disclosed the data of his colleagues, and so vicarious liability could not be successful. Bringing everything you've heard from Chris and I today together, what are the implications for employers arising out of this developing world of data protection law? Well, there are 4 points that we'd like to give you to take away. The first, and in many ways the headline point, is that data protection claims are going through a period of evolution, and they can present a significant financial risk to employers, either in the size of each individual claim or, as we see in the Google iPhone case, the combined total of a large number of claims. The possibility of their use of information leading to one or many claims against them should be something on every employer's radar. Second, the most fertile ground from the perspective of a claimant is likely to be breach of primary obligations on the part of an employer. As we've heard, there are a number of avenues that a claimant could potentially go down in bringing a database claim, and not least under the quite expansive and slightly woolly wording of the GDPR. However, it does need to be kept in mind, point 3, that there are some situations where primary liability just isn't going to get the claimant over the line, as we saw in Morrison's. And it's in these cases that vicarious liability really comes into its own. However, when considering vicarious liability as an action, the first step of any litigator needs to be to carefully consider and honestly consider in what capacity it's likely to be said the employee was acting. If they were acting to some degree or other, however strange their actions may be, to further the interests of their own employer, then vicarious liability may be a productive avenue to go down. However, if they are acting deliberately to harm their employer or to further their own interests in a different way, so they're using the information to set up their own business, for example, then vicarious liability is likely to be harder to establish. Now, I'm afraid that brings us to the end of our time with you this morning. In fact, I think we've slightly overrun. But as Chris mentioned at the start, if you have any questions on what we've covered today, then do feel free to email or call either Chris or me. Our contact details were on the first slide. They can also be found on the website, or you can always call our clerks and they'll put you in the right direction. I think I'm right in saying that a recording of the seminar will shortly be available on our newly minted 2TG YouTube channel, and the slides will be sent round by Deborah shortly after the seminar concludes. So all that's left for me to say really at this point is thank you again on behalf of both Chris and I for coming today, and take care until we see you next.